Do we want employers diving in to the sincerity of someone's religious beliefs to this level? And I think those facts must have mattered a lot when it came to applying this some harm standard from the Supreme Court.
Right. It's like it goes from just verifying the sincerity of your employees' beliefs to, arguing with them and asking or implying that they have it wrong. And so you may not give them their religious accommodation because of that. The facts did a lot of work in this case, like you said.
And we see it in other employment law contexts, too, when you're talking about the interview to apply for a job, but you're also in instances when you're talking about disability.
A fact check about religion that gets the law wrong, and the IRS does a Brazilian samba. This week, here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, October 7th, 2025, and we have two cases from the Federal Courts of Appeals to bring to you. One from the Sixth Circuit about religion and Title VII, and one from the Eighth Circuit about the IRS. But before you change the dial, because I don't want all that tax stuff, it is not every man's tax case. It's about some interesting new developments in constitutional and administrative law, and then how the IRS is not getting away with it, which is some good news for most of us. So joining me this week to bring these cases to you are my colleagues, Matt Liles and Christian Lansinger. So we're going to go to Matt in a moment for the Sixth Circuit case. But first, Christian. So he's going to tell us all about how the IRS reads its rules that Congress passes, how it does a little bit of dancing and making up its own rules along the way, and then how massive companies send massive amounts of money from their subsidiaries overseas, which is also always fun to talk about. But first, I do have a question for Christian that I warned him was coming, and that is, do you file your own tax returns?
I do file my own tax returns with of course, some help from tax software.
So you use tax software, and you're younger than me. I get this, but have you ever done a tax return where you wrote it out by hand?
No, I don't have the time to do that, nor the will to figure it out how to.
And Matt, you were saying you also do your own tax returns with the software stuff. Have you ever written out a tax return by hand?
I have not. I don't know where I would start doing that.
So I bring that up because back when I did not have very much money, and it was before software, let alone anything free that you could use. I did fill out my own tax returns from the age of 18, and it was, I gotta say, it gets kind of fun. Until we started dealing with, all the complicated stuff that happens when you get older and you get a little bit more money. And then I was like, I am going to commit malpractice against my own family if I continue to do this. So we started paying for the tax software. But we'll get to the IRS a little later. First, we have Title VII, which is the law that governs a lot of employment relations in the United States, and religious accommodations. And also, Matt knows that what this case has to do with has the Manhattan Project in the background. So there's a lot going on there.
That's right. So the setting of this case is very interesting. It ultimately does not have a lot to do with the law, but this case takes place at Oak Ridge National Laboratory in eastern Tennessee. And if you know your World War II history, that was built by the U.S. Army as a major site for the Manhattan Project. And it's where the Army enriched uranium when they were developing the first few atomic bombs. So very interesting history there.
So they took it from there, and then they'd take it to Los Alamos, and that's where they'd actually put the bomb together?
I think so. I think so, yeah. I don't know if they actually showed Oak Ridge in the Oppenheimer movie, but I think that was going on in the background.
Gotcha.
Yeah. But now it's no longer owned by the U.S. Army or involved in the Manhattan Project. It's now just a research facility for things like nuclear science and engineering, and it's co-owned by the University of Tennessee and a technology company called Battelle. So that's the defendant in this case is UT-Battelle. And this case is out of the Sixth Circuit called Jeffrey and Jessica Bilyeu versus UT-Battelle. What does Oak Ridge have to do with this? The Bilyeus are a married couple who are employed at Oak Ridge. They work there. It's not quite clear what they do, but I'd imagine it's something that I wouldn't really understand anyway. So, important to this case, the Mr. and Mrs. Bilyeu are committed Christians who believe that abortion is wrong. And so, as part of their religious faith, they consider it immoral for aborted fetuses to be used in any way in medical research. And that becomes a problem. In 2021, the owners of Oak Ridge, I guess this is mid to late 2021 during the pandemic, they impose a vaccine mandate, a COVID vaccine mandate on all of their employees at the laboratory that essentially says, get the COVID vaccine or get fired, more or less. And the Bilyeus object to this on religious grounds because I didn't know this fact, but apparently cells that had been originally extracted from aborted fetuses were used in researching and testing the COVID vaccine, which is an interesting fact. I guess I didn't know that. And so the Bilyeus object to that. They say, we feel like our religion compels us to not participate in something that's been developed using these cells.
And is it right, Matt? The mandate, it seems, is so the employer is putting the mandate on, but it's in response to the federal executive order, regulation, whatever it was at the time, that was requiring this of federal contractors. So it's kind of like, I believe so. It's kind of like the employer's like, I got to do this because the feds are saying we got to do this.
I think so, right? Yeah, the Biden administration at the time had a vaccine mandate on all federal government contractors, and I assume UT-Battelle, it qualifies in at least some ways. So that's right. Well, so Mr. and Mrs. Bilyeu, they object to this. They both seek a religious accommodation that would exempt them from having to comply. Mrs. Bilyeu realizes shortly after she can actually get a medical accommodation, so she goes ahead and gets that instead. But Mr. Bilyeu wants to get his religious accommodation, and his employer says, okay, that's fine, but you need to sit down for an interview or we'll kind of talk to you about it. And Mr. Bilyeu alleges that this is a pretty intense interview. From the evidence in this case, the Sixth Circuit opinion describes it as him being thoroughly examined about his religious beliefs. And very interestingly, so his employer sits him down. They hand him a fact sheet that first explains how cells extracted from aborted fetuses are commonly used in creating all sorts of vaccines and medications. So they say this is perfectly common. And then it has a section on the fact sheet also that quotes from a bunch of different religious leaders, including several different Christian leaders, where these religious leaders are saying essentially it's A-okay to get this vaccine. There's no good reason to have a religious objection to this. And so I think including quoting from some church leader in the Bilyeu's faith tradition, I don't think the Sixth Circuit opinion explicitly says which denomination or tradition they're part of. They're Christians. The opinion does quote repeatedly from the National Catholic Bioethics Center, I think it's called, which makes me think that they are probably Catholic. But
yeah, I think you're right. It doesn't exactly say.
Yeah. So Mr. Bilyeu reads this fact sheet. They ask him about it. He has to sign a statement certifying that he read the fact sheet and still wants to go through with his accommodation. And And then he gets his accommodation, but then the Oak Ridge employer has a policy that if you get this religious accommodation, you have to go on unpaid leave until the end of the pandemic.
So it's not really that much of an accommodation. You won't be fired, at least.
Yeah, you'll still technically be employed, but no one knows when the end of the pandemic's going to be at this point, and so it's kind of like an unpaid indefinite leave. And the opinion, I think, notes that they did not require this for medical accommodations, only religious ones. So the Bilyeu sue under Title VII of the Civil Rights Act for religious discrimination. They have a couple different claims: a disparate treatment claim, a retaliation claim. And we can just quote from Title VII. Title VII makes it unlawful for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of that individual's religion. And the district court ultimately rules for UT-Battelle, for the Bilyeu's employer. It holds that their employer didn't actually take a real adverse action against Mr. Bilyeu, which is one of the requirements or one of the elements of a Title VII claim. And so he doesn't have any Title VII claims. And the Bilyeu's appeal, and that's where we get the Sixth Circuit vacating in part and reversing in part. So the Sixth Circuit panel consists of Judges Bush, Seiler, and Kethledge. It's an opinion from Judge Bush. And the nutshell of it is the court is having to decide what are the standards for a plaintiff proving a religious discrimination claim under Title VII. What do they have to show to win at summary judgment under Title VII? Quick footnote, the first thing the Sixth Circuit does is addresses Mrs. Bilyeu. If you remember, she originally asked for a religious accommodation, but then realized she could get a medical one, and so got that instead. And she didn't lose any time or lose any pay in the short interval between those two things. So the court says she doesn't have standing to bring a Title VII claim, so she's out. She's kicked out of the lawsuit. But then it gets to Mr. Bilyeu, which is kind of the meat of the case here. The first claim that the court addresses is his disparate treatment claim. So a claim that his employer treated him differently on account of his religious belief. And so one of the elements of a disparate treatment claim under Title VII is that you have to show that your employer took an adverse employment action against you. And some circuits, including the Sixth, have interpreted that requirement as meaning a material adverse action, or you might say a really big or serious adverse action. So things like not being hired or being fired or reassigned or changing up your benefits in a big way. The effect of this interpretation is, you only have a religious discrimination lawsuit under Title VII if you've suffered a serious harm. So your boss kind of looking at you funny in the hallway is probably not enough, but if you're demoted from your position, that would absolutely be enough under this standard, the way a lot of federal circuits have interpreted it. So, and there's a case from about 15, 20 years ago from the Sixth Circuit where the court interpreted adverse action as not applying to being put on unpaid leave to accommodate your religious practices or beliefs. And I believe in that case it was a case called Tepper. It was a plaintiff who had been put on unpaid leave by their employer only on Saturdays because they went to church on Saturday or had some religious practice on Saturday. And the Sixth Circuit said that's not a material adverse action, no Title VII claim. And so relying on that case, the district court here said the fact that Mr. Bilyeu was put on this unpaid indefinite leave is not enough of a material adverse action to have a Title VII discrimination claim. We rule against him at summary judgment. But very importantly, the Sixth Circuit notes in this opinion here, last year the Supreme Court decided a case called Muldrow versus St. Louis. And this was after the district court's decision in this case. And the Supreme Court said, hey, lower courts, actually, we're going to stop you from doing this material adverse action heightened standard. We don't think the the text or language of Title VII compels plaintiffs to have to show a serious or substantial harm to them to have a discrimination lawsuit. The text of Title VII doesn't use that language. It prohibits all discrimination on account of religion, not just really bad discrimination. And so the Supreme Court says, in circuits, including the six, that require this material adverse action, we're not doing this anymore. You need to stop doing this. It's okay for a plaintiff to just show some amount of harm resulting from religious discrimination.
Or any discrimination, right? That's covered by Title VII, like sex discrimination in that case.
Right. Yep. Title VII covers all sorts, and it covers sex. In that case, it was I believe, a female detective in the police department who was reassigned from a undercover job where she did, they call it high visibility cases, to a role where she's wearing a uniform and not doing quite as important or like earth-shattering stuff. And the court said, that's fine, that's enough.
Right.
That's enough to show discrimination under Title VII. So the Sixth Circuit says we have been effectively overruled on this point, and so we are just going to have to say we're going to have to remand this claim back to the district court, vacate its holding at summary judgment, and the district court on a first look is going to have to apply this new standard from the Supreme Court and decide whether the facts that he was put on this indefinite unpaid leave is enough to show an adverse action under Title VII. I will say the Sixth Circuit's opinion has a footnote where they say, they kind of drop a hint to the district court, I think, that, they call it an involuntary, indefinite, unpaid leave. They distinguish it from the unpaid leave in the old Sixth Circuit case that was just for Saturdays. They say that kind of makes sense, but, to effectively fire someone without nominally firing them has to be enough, I think, that's the thrust of that footnote. So the district court will get to decide, but I think there was a bit of a hint in this opinion. And then the Sixth Circuit moves on to Mr. Bilyeu's retaliation claim. So you can have a claim under Title VII that if you were engaged in some sort of protected activity, so making a charge of discrimination against your employer, something like that, and then your employer takes an adverse action against you because of that, then you have a Title VII retaliation claim. It's kind of similar conceptually to a First Amendment retaliation claim in a way, but having to do with the kinds of discrimination that are prohibited by Title VII. And so this is an interesting break in the opinion because for a retaliation claim, you also have to show that your employer took an adverse action against you. That's one of the elements. You have to prove it as a plaintiff. But the Supreme Court, in its decision last year in Muldrow, actually says we're not going to touch the standard under retaliation claims. So a lot of circuits, including the Sixth Circuit, under Title VII retaliation, require you to show a material adverse action, so a very serious or substantial adverse action. The Supreme Court says we're not touching that. That's not what this case is about. This case is about disparate treatment. So we now have a situation where you have two different Title VII religious discrimination claims that both require an adverse action, and they have different standards. So for retaliation, you still have to show something more than just, some harm, or something more than just a little bit of discrimination, to put it very reductively. And so the Sixth Circuit now has to decide whether the district court got it right. The district court in this case also held for the employer and held against Mr. Bilyeu and said this interview he went through for having to put in a religious accommodation request is not enough. It's not a material adverse action. And the Sixth Circuit, I've got it here. The Sixth Circuit says, well, Mr. Bilyeu's theory of retaliation in this case is he puts in his religious accommodation request, and then they put him through this whole ordeal of this very thorough interrogation of his religious beliefs. And, I think he alleges they're kind of accusing him of being a hypocrite with the fact sheet.
Yeah,
like
more
saying,
than kind of.
Yeah, yeah. And so his theory is that this is Title VII retaliation. The Sixth Circuit doesn't buy that on its own. I think it says it's not right to say that his accommodation request on its own caused him to be on unpaid leave. It's more his employer had this policy that if you got an accommodation, you'd go on the unpaid leave. But the Sixth Circuit disagrees with the district court and says, we think there's all of this evidence beyond him putting in an accommodation request that I think a reasonable jury could conclude that he was retaliated against. It points to the thorough examination, the interrogation interview, where they are asking him repeated questions about his religious and moral views and kind of implying they disagree with him on his own views. They point to the fact sheet, and the Sixth Circuit says a reasonable jury might conclude that the fact sheet crossed the line from education into proselytizing employees as to whether vaccinations are sinful. So it kind of takes a view that his employer is taking a religious stance and being like, no, we know what your beliefs are actually. And beyond just assessing whether you're being sincere about this, we are going to argue with you about it as to the substance of what you're saying. And the Sixth Circuit panel says this is absolutely evidence a reasonable jury could use to find retaliation in this case. And so we're going to reverse the district court on this point, send it back down, and it's going to have a jury trial about retaliation, put it in front of the jury.
Well, that would be an interesting jury trial to watch, and that would be one you would want to get a very good jury consultant for, I would say. Christian, thoughts you have about this case?
I think we got to point out some of these questions that were asked during the panel interview, or I think interrogation, whatever you want to call it. They asked him, quote, it forced Mr. Bilyeu to explain why he took a position that conflicts with that of his religious leader on the COVID vaccines. And he was also asked to explain why working for UT-Battelle, which allegedly, quote, uses fetal cell lines in the course of performing its missions, unquote, did not, quote, offend his religious convictions, yet taking this vaccine did. And so it's like, that's where I think the facts are really doing a lot of the work here, where it's like, if that's not enough to show that there was at least, like, do we really want this where we have employers diving in? We don't really seem to let the government do that when it comes to a free exercise clause case. Do we want employers diving in to the sincerity of someone's religious beliefs to this level? And I think those facts must have mattered a lot when it came to applying this some harm standard from the Supreme Court.
Right. It's like it goes from just verifying the sincerity of your employees' beliefs to, arguing with them and asking or implying that they have it wrong. And so you may not give them their religious accommodation because of that. The facts did a lot of work in this case, like you said.
And we see it in other employment law contexts, too, when you're talking about the interview to apply for a job, but you're also in instances when you're talking about disability. We see these in other areas of employment law. We don't necessarily want employers asking these intrusive questions that kind of get to someone's identity. And this kind of is tying a bow on what the rest of employment law currently is and applying it to a religious context under Title VII.
It does also, and I'm glad you brought those other examples up, Christian. It does also show you a bit of the minefield that if you're an employer, you have to walk through when you have employees who bring up these reasons that you need to give them some kind of reasonable accommodation, because the kind of just common sense maybe approach or just first thought that many people in who are bosses might have is to you never brought this up before, really? Are you do you even know what we do down the hall? Like, you've been dealing with that for years and you never said anything, and now, right? And so what they're really getting at is now that it's politically charged to get this vaccine, it's coming up, and so that you just want to do that, not really for religious reasons, but for some other reason. And you can see all kinds of other ways where that would come up. I mean, the most obvious one is, do you really have a disability, right? When people say, well, I can't work because, my leg is doing such and such, and oh yeah, well, yesterday I saw you walking down the road just fine. Like that's the most extreme example, right? Where the employer really could dig into that. So it's a reminder, if you're an employer in this day and age, you got to be careful of your employees and know what the law is. And if whatever claims you have about whether Title VII should be written this way, the Supreme Court says it's written this way and it's enforceable. And so you got to mind your P's and Q's. But it also it does seem like this was on the run of different religious accommodation cases under Title VII, that they were not very careful here.
I'm also curious,
especially with the fact sheet about religion, which I just think is hilarious. Anyway.
Well, I'm just curious. This opinion, I think it was issued September 29th, if I'm correct. And when I was looking up this case, I saw on September 30th, the day after, the EEOC released a press release talking about a settlement in regards to UT's practices. So I don't know what's going on underneath all of this, but there it sounds like there was some kind of EEOC complaints. I'm not entirely sure of how those procedures work, but it sounds like there were a bunch of other like class plaintiffs, or however the EEOC complaints are exactly structured. And I'm just kind of curious why this case is separated from that complaint. It said they settled for $2.8 million to deal with COVID-19 religious discrimination charges. And I have to imagine this fact sheet played a role in that.
Probably. I would guess too, yeah.
Yeah, look, it's not one of our public interest friends litigating this case. It's who knows, they could be in the background, but it looks like he's got some. The appellants, they had some, well thought of lawyers on their side, and so who knows what the big story is there. If you know, dear listeners and viewers, please write in with the news. But thank you, Matt. We're gonna turn from religious news to Brazilian tax news of a kind, and this has to do. We were talking about before we started recording with a good friend of many of my friends, and that is the 3M Corporation. So this is like I don't know if it's the biggest employer in Minnesota, but it's one of the most massive employers. So that's where I live, in the eastern suburbs of the Twin Cities. And there are, like, you drive down a road near where I live, and half of the people in those houses work at 3M. As there's all kinds of engineers and other folks working there. You occasionally run into someone who says, "Oh yeah, my grandpa was the Post-it guy, and so that's why we're rich." Right, so there's all this 3M money going around because all these people inventing stuff, like at the labs we were talking about, but this time it's Scotch tape and all the other great things that 3M does, and I don't even know about. I think they do pharmaceuticals too, or they used to. Anyway, 3M, because it's global, it has subsidiaries all over the place, and it has this subsidiary in Brazil. And so that's where Christian's gonna tell us what happened to their Brazilian money, and what did the IRS think of that?
Yeah, so I don't have a Manhattan Project background for 3M, but I will say, beyond Scotch tape and Post-it notes, that maybe several listeners can look in front of them and see the 3M logo right now.
It stands for Minnesota Mining and Manufacturing, by the way. I forget.
Right.
The mining, I think, not so much these days, but that's the full name.
Right. So anyways, I think they actually developed the N95 masks as well. So there's their COVID tie for you. If there's a way to tie Matt and I's cases together. That and intervening Supreme Court case law, which we'll get to in a moment. But as Anthony alluded to at the beginning, this case kind of is the intersection of tax law, statutory interpretation, administrative law, areas that, may not sound super interesting on the forefront, but there's a lot of constitutional law and, frankly, new administrative law concepts underlying this case, which makes it quite interesting, and it helped. The opinion was, frankly, I think, really well written and made for an interesting read. But anyways, to talk about how this tax structure works, 3M has a U.S. parent company, and they have a Brazilian subsidiary. And how it works is the Brazilian subsidiary pays royalties or a royalty fee back to the parent company in the United States for the trademarks and patents that 3M has. And both the U.S. and Brazil need to figure out which money is theirs to tax. And unsurprisingly, both of them want to have as much of the income that 3M generates to be under their country and not the others. So that's kind of where this fight starts to begin, because Brazil has a law that caps the amount of royalty fees that can go from 3M's Brazilian subsidiary back to the parent company. So under this cap, there's a lot of complicated discussions about how this cap works, but in practice, 3M was capped at providing $5.1 million in royalty fees back to the parent company. So only that $5.1 million is considered taxable income for the parent company in the United States. Uncle Sam wasn't too fond of that. They wanted more royalty. They felt that these intangible property interests in the trademarks and the patents, that they exceeded that $5.1 million value. The Brazilian subsidiary was getting a lot more out of it, and therefore they should have been paying more to the U.S. parent company. So what the IRS did is they had an audit. These are 2006 statements, and I'm not sure why this has taken going on 20 years at this point. But what they said was, we don't care that Brazil stopped you from providing additional royalty payments. Under our code, Section 482, we're allowed to reallocate the income between the parent company and the subsidiary if we feel you're shifting your income in a way to avoid taxes, or you're just not paying us enough, and we want to make sure that the money that you are paying on what you're filing on your tax form is reflective of the income you've actually generated. So although they had $5.1 million in royalties, the U.S. parent company, in their 2006 filing, the IRS said, no, that should have been $28 million. So we're going to tell you that the difference, you need to make up the difference in taxes, that $23.7 million. You need to pay taxes on that from back in 2006 to prevent this, what they think it may be some kind of tax gamesmanship, even though, as the court determines, there's really nothing going on here, and they admit as much during the proceedings. They say, like, this is just the Brazilian law prohibits them from sending the royalties back to the U.S. parent company. So the IRS says that not only Section 482, it's ambiguous. We're not really sure what it says, how to deal with this situation where you have a foreign law that is saying you can't send the royalties back. But they happen to pass a regulation that favors Uncle Sam. And that regulation, the blocked income regulation, allows for this instance, and where the IRS will basically say, even though the income is blocked, we're going to treat that as income of the U.S. parent company. And they say, well, we should follow this regulation under Chevron deference, which I'll get to in a second. 3M's not happy about this. They don't want to pay more taxes. So they go to the tax court. And in 2023, the tax court issues and I kid you not, 344-page decision with 5 different opinions, 9-8. It's a plurality decision. In which,
that must be a fun court to practice before, let me tell you.
I imagine, I can only
tax
imagine.
Stuff.
But you have 17 different judges, all with their varying views on how to apply both Section 482 and this IRS regulation, the blocked income regulation that's underpinning all of this. And I confess I did not read the opinion, but the gist of what matters here is the plurality ultimately applied Chevron deference, and 3M appealed that decision. So to back up for a second for a legal background, this tax court decision was issued in 2023. That was during this 40-year period where the courts gave administrative agencies kind of a leg up when it comes to interpreting the law. And what I mean by that is to say that if a statute was determined to be ambiguous, in this case, Section 482, and the agency's regulation is reasonable, courts will defer to the agency. So that's how this worked for 40 years, from 1984 up till 2024, the year after the tax court decision. At that time, and again, this is where the kind of the interim SCOTUS case comes in, similar to Matt's case. In the interim, Loper-Bright came down. And Loper-Bright, as maybe several listeners know, was a case that overruled Chevron. And it said, we don't give agencies this special deference when it comes to interpreting the law and their regulations and how they feel Section 482 should be interpreted. And again, shockingly, in their favor. Under this new rule under Loper-Bright, courts must interpret statutes themselves, and they may regard agency interpretations as persuasive, but not binding. Ultimately, the courts have an obligation. They're the interpreters of the law, and they need to say what the law is. So 3M goes to the Eighth Circuit and says, we have this Loper-Bright decision. We need to actually dig down into Section 482 and go word by word. Let's talk about what this tax code actually is saying, and not give special credit to the IRS's own reading of it in their regulation, which conveniently, they passed this regulation 2 years after a court disagreed with their interpretation as to allow for this income to be treated, or allow this blocked amount to be treated as income. They passed this regulation 2 years after that court decision. So in going to that Eighth Circuit decision, they completely start out with the sentence, statutes trump regulations. And they start afresh. They don't look at the regulation or really discuss it until towards the very end of the opinion in passing. But they go through applying Loper-Bright in one of the first major cases to happen since that decision. They interpret the statute on their own, and they apply every statutory tool at their disposal: precedent, text, history, structure. They go through and really dig down into Section 482. And I won't bore listeners too much with it, but the gist of it is the Section 482 says the IRS may, quote, allocate gross income among related entities if necessary to prevent evasion or to clearly reflect income. And so the question is, what does income mean? And the court turned to a 1972 decision, so this is pre-Chevron, interpreting Section 482, where the court said that when it comes to income under this law, it needs to be money that the taxpayer has control over, dominion over. So think money that you could spend, save, or reinvest. In this instance, the U.S. parent company, 3M's U.S. parent company, didn't have control of this money. It was still with the Brazilian subsidiary. This is fictional income that's being taxed by Uncle Sam because Uncle Sam wants a better payday. So under this, applying this precedent that predated Chevron, the court determined that sentence means income can only be taxed when it's actually under the control of the taxpayer. And they rejected the IRS's attempt to kind of restructure their argument, because if you recall from the tax court, they were saying the statute's ambiguous, we don't really know what it means, which is what they do in these instances. And they say, well, let's look at our regulation because we have this deference. They kind of had to switch gears and totally just ditch that prior argument, which
right, the incentives are all different now.
Right.
Yeah.
And now they have to say, no, the statute is super clear. And what the statute says is income should be this income, or this amount rather, should be treated as income. And they point to the second sentence of Section 482, which just says that, and I'm looking here, it's in the cases of transfers or licenses of an intangible property, the income must be commensurate with the income attributable to the intangible, which is a complicated sentence, but the gist of it being that in the view of the IRS, the money, the royalties that weren't being sent to the U.S. parent company should be treated as taxable income under this sentence, because ultimately they're just trying to value what the Brazilian subsidiary got out of these patents and trademarks and other things that they were benefiting from the parent company. And the Eighth Circuit said no, but this rereading and reconstructing the second sentence to unwind prior precedent, it doesn't fly here. And it goes so into detail to even discuss, and I think it has a dictionary definition of what "the" means. With the income referring to the gross income in that first sentence, which had already been interpreted by the Supreme Court to mean income that the taxpayer has dominion or control over. And they go into detail with dictionary definitions. They talk about the statute's broader context. They mentioned that every term should be given meaning, and if we're giving the second sentence this much meaning, then what does the first sentence even mean? And they really pushed the parties during oral argument, and they multiple times a judge, is it Strauss? Is that how you pronounce it?
Yeah, Strauss.
He multiple times he said, "Where's the grammatical hook?" to the government attorney, and was trying to push the government attorney to go back to the language of the statute to really engage with the language. And then the opinion ultimately ends that, finished with this grammatical lesson or grammar lesson, they concluded that the U.S. parent company of 3M never had control over this $23.7 million that was always in the hands of the Brazilian subsidiary. And because of that, applying Loper-Bright, it doesn't really matter what the IRS regulation has to say. They throw it in at the end to say, this is what the IRS says. We've just done the reading for you. That's not what it says. It doesn't say that this fictional income that was never received by the U.S. parent company, that's not income under Section 482. So this case matters because it's, like I said, one of the first cases to really dive into what do we do with Loper-Bright. And it'll be curious to see. The 11th Circuit has a very, very similar case with Coca-Cola, which also has a Brazilian subsidiary, which also had a 2023 tax decision that largely a tax court decision, which relied heavily on the 3M decision to say that Coca-Cola, the U.S. parent company Coca-Cola, owes more taxes. It'll be interesting to see how those judges pan out, if they read the statute the same way. But we could see a lot more of this after the Corner Post decision that said that you can challenge regulations upon the statute of limitations starts running when you're harmed by that regulation, not when it was written. So
Right.
We could really see a lot more of these tax regulations, which I imagine if any regulation gets deference prior to Loper-Bright, it was probably these complicated and nuanced tax provisions.
Yeah, with
where
not the
IR
most sympathetic, parties involved, it's massive
Right.
corporations.
But now it looks like even the IRS, even Uncle Sam, is under fire for trying to get more money than is due. And it'll be interesting to see how these tools play out in the future. But for now, the Eighth Circuit said it's our job to interpret the law, not the IRS. And we're going to reassert our authority that's been dating back since Marbury versus Madison to say what the law is.
Judicial engagement, you might even call it. We have a special place in our heart here at IJ about litigating against the IRS and deference to the IRS's view of the law. As my friend and colleague Dan Albin had an early victory in his career when we sued the IRS about when they tried to put unlicensed tax preparers out of business. Speaking of preparing your own taxes. And that case, I think, is still cited today. Dan's victory from over a decade ago now. So Matt, even though you haven't written out your own tax returns, I know you're into this admin law stuff. So what are your thoughts on the issue?
Yeah, I will say to start, if you are an IRS hater, then you might enjoy reading the last half of this opinion. There's a good amount of, I read it as having some impatience for the IRS's litigation strategy in this case, and it's nice to see. It's nice to see a little bit of impatience with the government sometime. Here and there we get one. Yeah, it's interesting. I thought, Christian, your explanation of this was very good. It is one of the first big post-Loper-Bright decisions, and it's almost kind of weird to read an opinion where the court is, treating an administrative agency as any other party and reading the statute just the way it's best read, with no sort of kind of influence or deference in either direction. And I thought that was really interesting. I did like the bit you pointed out where I just love when courts get into little grammatical exercises when trying to interpret a statute, and the bit where you introduce the word income in the first sentence. In the second sentence, if it says the income, the only plausible reading of that is it's referring back to the same meaning as the first sentence. And it's the fact that is such an important part of reading the statute, and it makes a ton of sense, I just think is great. I love little grammatical exercises like that.
Yeah, grammar mavens will enjoy this opinion. Here, one sentence that I particularly liked. One feature of the English language, which usually goes unnoticed in the background, is that the first mention of a noun is often introduced by an indefinite article like a or an for singular nouns, a dollar, or no article at all for plural nouns, dollars, and mass nouns, money. So that gives you a flavor of how the opinion proceeds. Well, I hope all of our tax lawyer listeners enjoyed that. And I hope everyone else did as well for the larger ramifications of how the administrative state is being judged these days. So we'll stay tuned on further developments on that. I'd like to close now for something we haven't done in a while, and that is, where are they now? So where are they now, these past cases that we've discussed on short circuit that then sometimes they get remanded, sometimes they go en banc, sometimes they go to the U.S. Supreme Court. Now, it is Tuesday, the day after First Monday, where the court starts its October term, so that's OT-25 now. And so the just had the long conference. It where it reviews all the cases that have built up over the summer. It granted cert in 5 cases, and then it denied a whole bunch of cases just yesterday on Monday. Now, I'm happy to say that there are no cases we have discussed on short circuit that were denied cert in the long conference, and I don't think any of the 5 that were granted cert we talked about either. So there will be more to come. We're on our tracker of cases that we have discussed on short circuit. There are a few that are building up at the court. Really, the only one to mention that we have talked about in the past, and this one actually is still in the courts of appeals. So some listeners may remember, as a while ago now, on short circuit 350, we talked about this case involving property in, so this is another tax case, property in, or tax, I should say, in forfeiture, in Liechtenstein, that this taxpayer had, or that this owner had, and the U.S. was trying to get its hands on this property in Liechtenstein, and there were all these arguments about jurisdiction and extraterritoriality and stuff. So anyway, the property owner won, but then it went en banc. It was briefed en banc. Then the opinion was withdrawn. So the original 3-judge opinion, en banc, was denied, and now they're going to re-argue the case, but just with the 3 judges. So my reading of this is that the judges kind of went out on a ledge, like pushing back against this forfeiture, and now they're getting a little bit of cold feet. And so this is going to be re-argued on December 18th. So the wheels of justice turning very slowly for this case, December 18th, 2025. And then who knows when the opinion will come out after that. But as always, we will be watching it here on Short Circuit. And thank you to our Short Circuit guests today, Matt and Christian, for coming on. We hope everyone enjoyed this show. We hope you'll enjoy the live show we have coming up in a future episode from George Mason University. But until that time, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.